Court is on the record in the City of Conneaut versus Keith Garvin, 25 CRB 91. On April 7, 2025, Mr. Garvin pled not guilty to one count of domestic violence, a first-degree misdemeanor. We conducted a first pretrial conference on April 14, 2025. This case is set for a second pretrial conference today. In the meantime, on April 29th, 2025, the law director filed with the court a motion to revoke Mr. Garvin's bond. And so the court also, in addition to the pretrial conference today, the court also set this case for a hearing on the motion to revoke. This case was set at 9 a.m. today. The defendant was given notice of the hearing today. We have a signed receipt in the file show he was given notice at his last pretrial conference. It is now 9:16 a.m. and the defendant, Keith Garvin, has failed to appear. Present in the courtroom is his attorney, Philip Heasley, law director John Lewis, and Officer Pinkett of the Conneaut Police Department. Mr. Heasley, can you advise us to where your client is?
Yes, Your Honor. Thank you. My client's whereabouts are currently unknown to me. I will say for the record that notice letter for him to be here today at 9 a.m. with the time and date in bold print did go out to him. And we have not heard from him, Your Honor. And furthermore, as of today, I have been provided with additional discovery regarding the alleged incident regarding the bond revocation hearing. So, unknown, Your Honor, and I'm sorry to say that. Thank you very much.
Have you attempted to reach him this morning?
I have not done that, Your Honor.
I thought you told my bailiff that you attempted to call him this morning.
Not this morning, Your Honor. So, I'm sorry if I indicated that. No, that was...
Do you have a good contact number to call him?
I will check, Your Honor.
You know, Mr. Heasley, if your client, and that happens fairly frequently, when your client fails to appear and you have contact information, you shouldn't have to wait for the court to tell you to call him.
Yes, sir.
I mean, you've been doing this long enough to know to get on the phone and call him even before we go in the courtroom. Don't even worry about it. He's not here. I'm revoking his bond. I'm issuing a warrant for his arrest.
Buckle up, guys. Today we're going to witness a courtroom drama unfold in real time. The case of Kanye versus Keith Garvin kicks off with high tension as the defendant fails to appear for his scheduled hearing. The judge, unimpressed, immediately revokes his bond and issues a warrant. The courtroom is left in suspense. Attorneys scramble, and the stakes skyrocket before the first words are even spoken.
For his arrest, no bond will be imposed on that warrant. We'll reschedule anything in this case until the defendant is incarcerated and the warrant is executed. You know, for the benefit of your client, you may want to do that in the future, but too late now. I'm revoking his bond and issuing a warrant.
And, Your Honor, I don't see a phone number in our contact information for what that's worth. So, the bond will issue. Thank you. Thank you.
Anything further, Mr. Lewis?
No, Your Honor, thank you.
Okay. This matter is concluded. I'm sorry that all the witnesses are inconvenienced.
Mr. Garvin, have a seat.
Court's back on the record. City of Conneaut versus Keith Garvin, 25 CRB 91. Mr. Garvin comes strolling in at 9:25 a.m. Case is set for 9 a.m. Where you been? Excuse me? Home. Take him into custody, hold him, and then we'll make you think about being on time. Seriously. We're revoking your bond. Tired of people being late. I've got a full docket today. Full docket. You know you're supposed to be here at 9. Okay, the court is back on the record in City of Conneaut versus Keith Garvin for the third time. Case number 25, CRB 91. The court instructed Officer Pinkett to bring Mr. Garvin back up from the jail so we can proceed with today's hearing and pretrial conference. Mr. Garvin is present. He's accompanied by his attorney, Philip Heasley. Also present, Law Director John Lewis and Officer Pinkett sitting at the Law Director table. Mr. Garvin, does your attorney know how to get a hold of you?
I left like 4 different voicemails.
You left him 4 different voicemails? Does he have your phone number?
I just have his contact number.
Write your phone number down. You got it?
Yes, sir.
Okay, that's good, because earlier a few minutes ago, Mr. Heasley reported he did not have contact information for you. So, when did you leave these 4 voicemail messages?
I believe the first one was the day after court.
Do you guys even have voicemail at the public defender's office?
We have voicemail, Your Honor.
I'm not even going to get into that.
Okay.
You know, if this is true, because now I'm really steaming. Why were you late today?
I thought I was at 10. I thought I was here 30 minutes early.
Yeah, well, I've got a signed receipt in the file showing that you signed a receipt with a 9 o'clock a.m. hearing date, or hearing time. So, you were wrong that it started at 10. Okay, counsel, have you guys talked about possible resolution, or are you ready to proceed with the hearing on motion?
I'm ready to proceed, Your Honor.
Okay. Mr. Heasley.
Thank you, Your Honor. We have just been provided with information regarding the revocation
What do you mean just provided?
earlier this morning from the prosecutor, Your Honor.
Well, you knew this hearing. You knew today was also scheduled for a hearing on the revocation, though,
Yes,
right?
sir.
Okay. So you're talking about like discovery information?
This is on an alleged incident from April 20th.
When I ask you what were you provided today with, is it discovery information about the revocation issue?
Yes, sir.
Okay. So what are you asking?
And I do realize the court has its schedule a minute or two to speak with Mr. Garvin regarding the revocation and whether he would admit to the same. And if not, we're prepared to have a hearing. Thank you.
Okay, go ahead. Take a few minutes.
Thank you,
You
sir.
know the court's schedule
Keith
today.
Garvin finally arrives late, and the courtroom tension spikes. The judge confronts him on his tardiness, emphasizing the seriousness of following court orders. The attorney explains discovery complications, and the judge stresses punctuality and responsibility. Every word builds suspense as the courtroom braces for the critical bond discussion, leaving viewers on edge about Garvin's fate.
Court's schedule today.
Yes,
We are stacked. We're going to be here until 5 o'clock tonight. So, back on the record, the City of Conneaut versus Keith Garvin, 25 CRB 91. Mr. Heasley, have you and your client had an opportunity to discuss this matter?
We have, Your Honor.
Okay.
He wishes a hearing on the revocation of bond. Thank you.
Okay, thank you. Any opening statements, counsel?
No, Your Honor.
Waive opening.
Okay, call your first witness, Mr. Lewis.
City would call Officer Dan Pinkett. Are you a certified peace officer in the state of Ohio?
I am.
I want to draw your attention to April 28th, 2025. Were you on duty that day?
Yes, sir.
And did you have any interaction with the defendant, Keith Garvin?
Yes, sir.
Okay, and how to tell the court, please, how that interaction transpired.
Sure. I returned to the Conneaut Police Department to meet with a male subject identified as Mr. Garvin in the front lobby of the police department. Mr. Garvin proceeded telling me that while in the vehicle with the mother of his child, Tony Martini, that she struck him several times in the face while they were going to get dog food.
Did that allegedly happen on April 28th
Yes.
in the city of Conneaut?
Yes.
He was in the vehicle with the alleged domestic violence victim, Tony Martini.
That's correct. Or he was being the victim in this case.
Told you?
Yes, sir.
Okay. What, if anything else, did Mr. Garvin tell you?
That while they were going to get dog food, he called his friend to go lock his front door. Mr. Garvin advised me that upset Miss Martini, and she became enraged and punched him approximately, if I do recall correctly, 4 times in the face.
Did you at any time take a written statement from Mr. Garvin?
Yeah, that day, yes, sir.
On that day?
Yes.
Okay. That's a written statement that Mr. Garvin provided to you on April 28th.
Correct.
Could you please read that for the court?
Sure. Tony Martini picked me up to get dog food. Then I called my neighbor to lock my door. That's when she lost it and punched me 4 times. She busted my lip, my neck, and jaw is swollen. So I called my friend to take me to the police station. And file this report. I'm sorry.
Is that signed by Mr. Garvin?
Yes, sir.
Did you witness him signing that?
Yes, sir.
I'm going to approach again, Your Honor, and did you obtain any other evidence in the case?
Yeah, I spoke to Miss Martini afterward.
Okay. And did she provide a written statement?
She did.
Okay. Did she provide anything else to you?
Yeah, she showed me a picture of emails from Mr. Garvin to her on her phone.
I'm going to approach the witness again, Your Honor.
Okay.
Do you recognize that photograph, sir?
Yes, sir.
And did you take that photograph?
I did, yes, sir.
What's depicted in the photograph?
It's emails from Keith Garvin to Miss Martini saying, hurry up. She says in the shower. He says, pull up real quick. And he says, the door go be unlocked. I don't even want to answer anymore. And it's from Keith Garvin. You can see it.
So the emails say that they're from Mr. Garvin?
On April 28th, that's correct.
The emails are dated April 28th?
Yeah,
And you took that photograph?
I did.
Appears to be a true and accurate copy of the photograph you took?
Yes, sir.
How about this statement? Does that appear to be a true and accurate copy of the written statement that Mr. Garvin gave
The
you?
focus
Yes, sir.
shifts to Officer Pinkett,
Thank you, Officer.
who steps forward to testify about the alleged incident on April 28th. He recounts Garvin's claims and documents the physical confrontation, presenting written statements and photographs as evidence. Each detail deepens attention, giving the audience insight into the escalating conflict between Garvin and the alleged victim, setting the stage for a critical examination of the bond violation.
Thank you. Cross-examination?
Thank you, Judge. Officer Pinkett, you interviewed both individuals in this matter.
That's correct.
Took statements from each of them.
Yes, correct.
And not to go over your testimony just a minute ago in word-for-word detail, but Mr. Garvin came into the police station and indicated that the alleged victim had hit him.
Or the suspect of them, he being the victim, that's
And
correct.
that would be Tony Martini.
Martini, correct. Yes, sir.
And then later, Ms. Martini was interviewed and her statement was taken.
That's correct.
Thank you. To your knowledge, finally, Officer Pinkett, since then, to your knowledge, has there been a repeat of any incident such as this one involving contact between the two?
Not to my knowledge, sir.
Thank you. That's all, Your Honor. Thank you very much.
Thank you. Any redirect?
No, Your Honor.
Okay. Thank you, officer. Your excuse.
Yes, sir.
So, Mr. Lewis, any argument?
Thank you, Your Honor. I think it's pretty obvious that there was contact between Mr. Garvin and he had contact with Tony Martini on April 28th, as evidenced by his own written statement that he provided to law enforcement, which is signed by Mr. Garvin. He clearly had contact with Ms. Martini, contrary to this court's bond order in this case. Also, Exhibit B shows that prior to that physical contact with her, there were emails that he sent to Ms. Martini.
You mean text messages? Yeah.
I believe they're emails. They're emails.
Oh, these are emails?
They're exhibited on her phone, but they're actually email
Okay.
correspondence. Yes,
Okay.
sir. So I think think it's obvious that the defendant had contact with Tony Martini on April 28th, contrary to the bond order of this court, which ordered him to have no contact with Tony Martini, and therefore city would ask that Mr. Garvin's bond be revoked and that he be taken back into custody. Thank you.
Cross-examination begins as the defense attempt to clarify the circumstances of Garvin's encounter with the alleged victim. Despite challenges, the city establishes that Garvin clearly violated the no-contact order. Suspense mounts as both sides argue over the significance of these actions. The judge listens intently, and viewers are left anticipating whether the bond will be revoked and Garvin taken into custody.
Thank you.
Thank you. Mr. Heasley?
Thank you, Your Honor. Just briefly in response, we heard what the officer said, and it began with my client, Mr. Garvin, reporting an alleged crime, an incident regarding the alleged victim, Ms. Martini, that may not be a defense to a no-contact order, which is what is before this court today. But I think it may very well be some sort of mitigating circumstance of some kind that is up to the court to determine. And what he said in his statement was clear, that she hit him. We're not here today for that. He's aware that a no-contact order is on and is still in effect, which is why we're here today. I believe they do have one child, is that correct?
Yes.
One child together, and he's aware of, he was just taken into custody earlier today, of the consequences of violation of no contact orders. Your Honor, we would hope that his bond not be completely revoked, that he could avoid going back into jail. The original case is still, of course, on and pending. And I think that earlier this morning gave a clear indication of the fate which awaits Mr. Garvin at the hands of the court. He does work at an establishment called Castaways, and he must avoid, under whatever circumstances there are, any further contact with the alleged victim in this, Ms. Tony Martini, and that is all. Thank you.
The defense steps in with arguments for mitigating circumstances, highlighting Garvin's perspective and personal dynamics with the victim. They plead for leniency, noting ongoing responsibilities and prior reporting of incidents. As the courtroom weighs intent against legal obligations, the tension is palpable. Observers see a delicate balance between empathy and justice, keeping the audience glued to each word.
Thank you very much.
Thank you. Any response to any of that, Mr. Lewis?
No, Your Honor.
So Ms. Martini didn't testify, and she's in the courtroom today. Ms. Martini? Which one is Martini? Ms. Martini, the evidence offered by Mr. Lewis through the police officer indicates that you were together with Mr. Garvin on April 28th, 2025. And the text message, or email, I should say, more or less indicates that you were a willing participant in this contact.
Yes. He asked me to bring dog food, and I did. And the only way that I was able to leave, he snatched my keys out of the ignition. The only way I was able to leave was if I took him wherever he wanted to go.
So you literally went to pick him up to get dog food?
No, he took a different picture of the emails. I told him to either leave the money or I'll just bring the dog food. And he said I'm not, or leave the door unlocked. And he said he wasn't doing none of that. So, but yes, I did go to the house, and that's when he got the keys, and he told me, or he said, you can't leave unless you take me wherever. Which I did have to take him to work, because he wouldn't let me leave. He wouldn't give me my keys. I actually had to take him to the store, to work, back to the house, and he tried to get me to take him back to work. But that's when he told me that he was going to come up here and make a police report. if I didn't take him back to work. So then he called a friend to pick him up to bring him up here.
Why dog food?
Because we have a dog there and he doesn't really take care of animals. So I'm
So you have a dog together?
not together, but I do. There is a dog at the house.
At the house he's at?
Yes.
Okay. I mean, Mr. Garvin signed a bond on April 7th, 2025. It's in bold print. It says that he is to have not consumed, possess alcohol or drugs, subject to random chemical testing, no contact with victim Tony Martini. I mean, no contact means no contact. I do find the defendant has violated the conditions of his bond by having contact with Tony Martini. So what would you like me to do, Mr. Now that I found that he's violated the condition of his bond?
All right.
Attention turns to the victim's testimony and Garvin's responses. The courtroom hears firsthand how the April 28th incident unfolded, the limits on movement and enforced obligations. The judge scrutinizes every statement, confirming that Garvin violated his bond. The suspense peaks as a ruling on bond revocation hangs in the balance, marking a turning point in this complex, emotionally charged case.
All right. Revoke the bond and place Mr. Garvin into custody. I mean, this is an ongoing situation, as the court is aware. Ms. Martini has informed me that she's filed an eviction proceeding against Mr. Garvin. The house that Mr. Garvin is residing in belongs to Ms. Martini. It's just an ongoing issue. And I believe, I didn't have Ms. Martini testify any interest in moving this proceeding along because I understand the court stopped in his slam today. But Ms. Martini told me previously that these emails have continued from Mr. Garvin to her beyond April 28th. I think that the facts here warrant, I mean, blatantly ignoring the court's order not to have contact with Ms. Martini. I would ask the court, I realize the jail is pretty full right now, but I don't know what other, obviously the court order is not going to work to keep Mr. Garvin from having contact with her. And I did discuss with Ms. Martini the fact that she's not to have contact with him either, in respect of the court order. So I did explain that all to her, Your Honor, as well. I indicated that Mr. Garvin has the rights of a tenant currently in that house, even though he's not, I don't know if he's paying rent or not, honestly, but he does have the rights of a tenant. This doesn't give her the authority to go into that house because he has the rights of a tenant. So it's one of those situations where you just kind of shrug your shoulders. This is clearly a blatant violation of the bond order. I would ask that Mr. Garvin be taken into custody and remain there until such time as the case is resolved. Thank you.
Thank you. Mr. Heasman?
Thank you, Your Honor. In response to that, we would hope that, although it is in the court's discretion to do that, we would hope the court would not. The court itself, although Ms. Martini, as Mr. Lewis indicated, did not testify, the court did elicit information from her directed towards the bench, and that only confirmed the fact that she was involved in the contact as well, from her end. That is not uncommon in these types of situations. There are personal ties between the two, and I would fully agree, as the court said a few minutes ago, that no contact means no contact. But Ms. Martini, in response to your own questioning, did indicate her role in this. Mr. Garvin must not have any more contact with her, either personally or by any other means, with Ms. Martini here. And I'm sincerely hopeful that that will not happen, and we will have a repeat of this type of incident pending the resolution of the underlying matter. I believe that the officer was asked if there was a repeat incident similar to this one on April 28th, and I do believe he indicated not to his knowledge. We would hope, Your Honor, that Mr. Garvin would not be taken back into custody. He does work. He must leave this woman alone and abide by not just that element of the court's interim orders, but also every other element thereof. So we would hope that he would not be taken back to jail over this, Your Honor. That's all. Thank you very much.
Thank you. This incident happened on April 28th. Ms. Martini, have there been any other contacts since April 28th?
Yeah,
How?
I don't know.
So he's emailing you.
Yeah, and I called and I reported it. I talked to Officer Keeslin, and she had me email pictures.
And do you respond to those emails? I mean, is this a
I
communication?
haven't, no.
What don't you get about no contact, Mr. Garvin?
Actually told my attorney she broke the no contact with the
Yeah, well, she's not ordered to have no contact with you. You're ordered to have no contact with her.
She came in the house the day after court, the initial hearing. I told Philip that. He didn't want to bring it up. He didn't want to have an attitude like we have right now.
Yeah, I've got an attitude because you were a half an hour late. That's why.
That's my fault. That's why there's no contact. She walked in the house. Walked through the back door. I told her there's no contact order, bro. This is my house. I can do what I want to do. This is the 8th.
Well, you know, an eviction, civil, that's a civil matter, and I'm going to be the one having to make a decision on that at some point if that ever comes to before me. I don't want to get into that. And nor do I want to use the criminal process to assist an eviction. Because I've been confronted with that in the past. Look, Mr. Lewis mentioned it. And Officer Pinkett knows full well that our jail is overflowing today. And Mr. Garvin, no contact means no contact. You don't seem to understand that. You're just like questioning, you know.
No, you said no contact. I just told you the day after our original.
I'm telling you, you're to have no contact with her.
She walked in the house. What am I supposed to do? She walked to the back door.
Well, you need to call the police.
Okay.
You need to call the police. And I don't know about these emails. I'm looking at an exhibit of emails clearly showing contact by you outside of her coming into your residence. If you have one more, any bit of contact with her while this case is pending, Mr. Garvin, I'll revoke your bond. You're going to jail, and I don't care. I'll stack you up in bunk beds on top of each other in a jail cell. I don't care. If it happens one more time, that's where you're headed. And Ms. Martini, you need to call the police if there's any further contact, and you need to stay away from him. Understood? We'll set this case for a final pretrial conference in the near future. Bond will continue as previously set, although I am finding that he did violate the conditions of his bond, and I will make clear that if it happens once more, we will revoke it and he'll go to jail.
As the case reaches its climax, repeated violations and ongoing tensions are addressed. The judge delivers a firm warning. Any further contact will result in immediate incarceration. Garvin's actions, a victim's role, and prior communications are scrutinized in detail. The courtroom holds its breath as the judge enforces accountability, cementing the consequences of disobeying the court.